Well, good afternoon, everyone. My name is David Tingstad. I'm the chair of the Business and Real Estate Group here at Beresford Booth. I have with me today my colleague Caleb Tingstad, also happens to be my son. We're a family affair here at Beresford Booth. Pleased to bring today's webinar to you, having to do with the techniques for resolving deadlock in LLCs and closely held corporations. Very much a challenging sort of atmosphere, and Caleb and I will have a conversation. Feel free to jump in with questions in the chat menu, and we'll try to get to those as we see them. Got about a half an hour here today to deal with these issues, but suffice it to say that these sort of resolution techniques are challenging, and every situation is going to be a little bit different. And of course, the goal is to avoid the deadlock or having deadlock in the first place, but sometimes that can't be avoided. So I'm going to share my screen. Caleb, how did I do? Am I looking at the right screen? All right, very good. So Caleb and I are going to talk about these issues, and before we get into a bunch of the techniques, it's really important, I think, that we understand the difference between corporations and LLCs as it relates to these deadlocks, because there are differences. So there's flexibility with how you handle voting in LLCs based on how your LLC agreement works. But I'm going to talk a little bit about the default rules with LLCs. And then there's no flexibility with how you handle voting in corporations. The statute tells you how you vote. It's one vote per share. Now with LLCs, it's different because it's one vote per member. Okay. Now that's a huge difference as it relates to deadlock, because if you have two members in an LLC, the default rule is you're set up for a deadlock right out of the gate, again, in the absence of an LLC agreement. But that's not the way necessarily that is if you have two shareholders, because with two shareholders in a corporate setting, one shareholder could have 90 shares, the other one could have 10. Well, you're not going to have a deadlock in that kind of situation. And so this comes as a surprise, frankly, to a lot of people, because the old LLC Act that we revised back in 2016, or became effective back in 2016, prior to that time, the default rule for voting was based on the amount of capital that you contributed. So now there's a change and how we handle voting. And so folks may be surprised to learn when you're an LLC member that your voting rights have nothing to do with what you contributed. It's also irrelevant based on the percentage that you have. So I could own 75% of an LLC and yet not have control over that LLC in the absence of an LLC agreement. So that's our default rule.
So just to be clear here, you and I form an entity. You contribute $1 million, and I contribute nothing in terms of capital. Maybe I contribute services. Even though you've contributed $1 million and I have contributed no capital, you and I still only get one vote in the absence of an LLC agreement to the contrary.
That's right. You and I, in your hypothetical, Caleb, we would be equal members. And that's why I say a lot of us might be surprised that that's the default rule. Certainly, the guy who put in $1 million would be surprised, right? And there is in that kind of situation, again, in the absence of an agreement, written LLC agreement, you're stuck with that one person, one vote. So if you and I don't agree on the color of the carpet, or whether it's day or night, or whether to close on the purchase of a business or a piece of real estate, the LLC is going to do nothing. Okay, very much a surprise. And so it's one of the reasons why I've written extensively on this subject. You got to have a written LLC agreement because to avoid exactly what you're talking about, Caleb. I mean, that would be if you can imagine the surprise that the guy who put in all the capital would have. And so an agreement, you can have an LLC agreement, though, that might say, no, whoever put in the capital gets all of the vote or gets to make the majority of the decisions. You, for example, might get to handle the day-to-day stuff, hiring and firing employees, or whether to have this kind of insurance or that kind of insurance, sort of the ordinary course sorts of things. But typically you'll have an LLC agreement that then says, okay, no, we're gonna this guy is gonna have a veto right, or we're gonna give that person the entire right to vote on certain things, because if I put in all the money, most of the time I want to have a large amount of the control. So contrast that now in the corporate setting, where there is no there's no variation with respect to, we do what the Model Business Corporation Code says. You're stuck with that unless you have a shareholder agreement. Okay, and in closely held corporations, and when I talk about closely held corporations, Caleb, I'm talking about a few shareholders, not publicly traded. Okay, you can imagine you're not going to have a shareholder agreement at at Microsoft or something like that, right? But if you and I are shareholders in a corporation, and there's all kinds of things that you would include in a shareholder agreement, but one of them would be, okay, I've got 50 shares, you got 50 shares. Well, in that case, there could be a deadlock. And understand, when I say deadlock, I mean we don't have enough votes to say yes. We don't have enough votes to say no, because you said no with 50, I said yes with 50. We're stuck, right? And it doesn't matter what we're voting on. Certainly there are different levels of votes that you have to have. For example, for major transactions in a corporation, selling all the assets, for example, there may need to be 2/3 approval. 2/3 of the shares would have to vote for something like that. But in the absence of that, right, majority rules. And so when you've got 50-50, you can't say yes, you can't say no, you're stuck there. Of course, if we want to take your example, Caleb, of the $1 million contributor and the $0 contributor, we would probably be thoughtful about, okay, who gets how many shares for $1 million, and who gets how many shares for $0 for services, I guess, to use your hypothetical. So usually people get that a bit in the corporate setting. It's much easier to understand that idea. Whereas with LLCs, for some reason, people seem to be much more like, okay, well, we're equal partners even though I put in all the money. In the corporate setting, people, no, we're not equal partners, because and why there's that sort of difference, I don't know why, but just in practice, that's the way that it is.
So can you explain to me the difference between, because it seems like you're making a distinction between deadlock, where you don't have enough votes to for a yes or no, versus a whether the default rule is provided or an agreement that provides that you need both, be it both members or both shareholders, to affirmatively consent before taking an action, because it seems like there's a distinction there, right? One is deadlock and the other is not.
Yeah, no, it's a great point. It's a great question. So, I think what might highlight this distinction is, let's say that we're electing directors, okay, in a corporation, and understand, and this is really important that we understand this, that really the only thing that shareholders have the authority to do in a corporate setting is vote. They primarily vote to elect directors, okay? And when you vote to elect directors, you vote your shares. I vote for David to be the director. And if I have the majority of the shares, unless we have what's called cumulative voting, then I get to elect all of the directors, okay? And it's just whatever majority rules, okay, for the election of directors and for the vast majority of things that you vote on with a corporation. So that's where we could have deadlock, if you have 50 shares and I have 50 shares, I vote for David, you vote for Caleb. Well, neither one of us received a majority of the shares. Who's a director? Okay. Now, to contrast that with the scenario where the corporation wants to merge with another entity, or it wants to sell all of its assets. In that situation, the Corporate Act says you have to have 2/3 approval to do that. Okay. Well, you vote yes, you've got 50 shares. I vote no. We're not deadlocked. Okay. We didn't get to 67% of the vote. Okay. So in two different examples, election of directors, yep, we're deadlocked. Major fundamental change transaction, we're not deadlocked. And I think that highlights the distinction. And by the way, you don't have those same default rules with respect to LLCs. Sometimes you have to have unanimous consent, for example, to admit a new member. Has to be unanimous. Again, a lot of these default rules might be surprises to people. So that's another reason I don't mean to get sidetracked by, hey, you got to have an agreement, but you got to have an agreement. It absolutely is most important. Now, what the slide on the screen still shows, there's a couple. What we haven't talked about yet is transferability. Okay. Now, why is that part of a presentation having to do with deadlock? Okay, because in a corporate setting, you can, in the absence of a shareholder agreement restricting the transfer, anybody can sell their shares to anyone at any time. Okay, whereas if in the LLC setting, the only thing that can be transferred, okay, the only thing that can be transferred from a default setting is the economic rights. Okay, but there's a quirk in our statute that gives a bit of a head scratcher. When you transfer all of your economic rights, okay, that's what we call an event of dissociation. All right. So if I take and I transfer all of my economic rights in my LLC to you, Caleb, I have unwittingly lost my power to vote, and I haven't transferred it to you. Okay, and so you can end up with an enormous problem. Maybe you thought that I could transfer economics, but I could still vote and cause a deadlock, and that's just not the way that it works. Whereas on the corporate side, you don't have to worry about that sort of stuff. You can assign all your economic rights, and you still have the right to vote. You can grant somebody else the right to vote. You can give a proxy. Well, you can give a proxy with LLCs too. But point simply is, major changes or major differences between corporations and LLCs that you may just think, well, it's just an entity, it doesn't really matter. It absolutely matters, and that choice of entity matters. Now that we transition into this idea of, okay, we've got a deadlock, how do we resolve it? So with any luck, So we've kind of talked about this issue already, but before I get into what the techniques are associated with deadlock resolutions, shareholders elect directors, directors appoint officers. They don't all have to be the same person, okay? But normally in a closely held corporation, people, they're working at the corporation, they're all in it together. And so a shareholder might be a director, might be an officer, an employee, all of those things, but it doesn't have to be that way. So you might have a situation where you have, say, 55% of the shares, and there are only 2 directors. You can end up with a deadlock in that situation if you're not careful, okay? Because with 2, if you have only 2 directors, remember, it's the directors who make the decisions, not the shareholders. So whoever the shareholders have elected as directors, if they're deadlocked, the corporation might be deadlocked. Okay, and that again, that may be kind of a surprise to some people. So for the directors to take any action, right, they've got to agree or have a majority of the directors to take the action. Well, if there are only 2, what do you do? Okay, So certainly there are other elections and firing of directors that can happen and regularly happens at shareholder meetings. But just from a deadlock perspective, if you got two, you got the basis for perhaps a deadlock. And then you can have different LLCs. You can have a member managed LLC, you can have a manager managed LLC. And you might have two members, might be 50-50, okay, but only one manager. And depending on what the authority that the manager has, maybe the LLC is not deadlocked, even though the members might be. So you've always got to be asking that question, okay, who's what? What hat are we wearing? And what authority does everyone has? Because shareholders have different authority than directors. Members have different authority than managers. And you, by the way, you don't have shareholders and directors in LLCs, and you don't have members and managers in corporations. Okay.
So if what are the consequences if you do not have an agreement determining what happens when deadlock occurs? I mean, what you and I are in a closely held corporation or an LLC, and we get to the point where there is a decision and we are not able to make the decision, and we don't have anything that gives us the idea of where to go. What are the consequences of that?
Right. Well, it's a great question, and really, sadly, you're left with really what I refer to as a blunt force instrument. Your only real remedy at that point is what we call judicial dissolution, and so instead of maybe having some ability to keep that entity alive, keep the business going, instead what we have to do is we have to sue each other. We have to stand in front of a judge and say we're broken, court. We cannot solve this deadlock. And by the way, there might be creditors out there swarming around. We might have personal guarantees associated with the entity's debt. We have employees that have to be paid. All of those people are stuck in the middle of our deadlock. Okay, and it's one reason why. I mean, these cases are absolutely fascinating how they play out, because the stakes are so high. But yet, that's it. That's why I refer to it as a blunt force instrument, because the only thing you can do is blow up the entity. Okay, and there's got to be a better way to solve that problem. And you put your finger on hey, we can all see this. We know this happens, and I say this all the time. If you can foresee it, plan for it. All right, look, we're two people. We might disagree. And by the way, so this is a great example. You and I, father and son. Do father and son ever disagree? All the time.
Never.
Yeah, right. Well, family. I mean, my gosh, it happens all the time. And yet what we don't do is we don't go, okay, what are we going to do to solve this problem? But at the beginning, while we're still talking, it's a great time to do that. So here we are. Let's talk about some of these techniques. Really important to do that. I've included 4 techniques on the slide here, and there are all kinds of variations within these. Okay.
With very fun names, I would add.
You like the, yeah, aren't they though? Yeah, we have there's no shortage of really cool stuff here. Arbitration, not maybe so fun, but arbitration is appointing another lawyer or appointing a judge to privately say, hey, solve our deadlock. David wants to sell the company. Caleb doesn't. What do we do? Okay, and you have to be really careful with arbitration, because it is much closer to kind of this blunt force idea, and arbitrators are notorious for taking the middle position, splitting the baby, as we say, and so there are different variations within arbitration. For example, there's what we call baseball arbitration, where baseball arbitration is, I have a position that I want to sell for $1 million, and Caleb wants to sell for 1.2 million to somebody else. I don't know why I wouldn't be in favor of selling for 1.2 million, but that's beside the point. Where the arbitrator doesn't have any discretion to split the baby, to make anything, to choose anything other than pick Caleb's position or pick my position. That's it. That's it. So that's what we call baseball arbitration. But that breaks the deadlock. I'm not a big fan of arbitration as a deadlock resolution technique because it's expensive and it's not as doesn't happen as quick as some other methods do. Okay, but a lot of LLC agreements contain an arbitration clause, or people just agree to go to arbitration. So it's a way. Another way is what I just refer to as resolver. Okay, so again, perfect example with Caleb and I. So here we are, and we can't agree over what we're going to do, but we have an LLC agreement, or we have a shareholder agreement that says mom is going to break the tie, brother is going to break the tie, sister is going to break the tie, or somebody outside the family. But you do it in advance, Caleb, to identify a human that is just going to break the tie, and it's not litigation. We're not taking depositions. Okay, I'm going to bring some why I think we should choose this course of action. You're going to bring something, and it's somebody we both already know. So that again, it's not, it doesn't even have to be a lawyer. Okay, but it's somebody who can break that tie. So rather than it being an arbitration, this arbitration has its own statute, has all kinds of process and procedure included with it. Resolver is totally a private thing. You get it into your agreement again at the outset while you're still talking. Choose somebody who you both trust, has some wisdom, knows you, and that person is gonna break the tie. Okay, so that's the resolver technique. All right. So now we get into a little bit more interesting and what I think are fun methods. And so yesterday I put out a blog post on the shotgun or cut and choose method of deadlock resolution. Okay, and so I like to use this example. To me, it makes the most sense. When I was a kid, there would be one piece of cake left. I would want it, my older brother would want it, and my mom didn't want to deal with petty disputes amongst her children. And so she would say, okay, Mark, which is my brother's name, Mark, you cut that piece of cake, and David, you get to choose which piece. And so my brother, and this is a true story, by the way. So my brother, Caleb's uncle, would go and he would grab the ruler and he would get the ruler out and measure that cake. And it's the most perfectly equal, two most perfectly equal pieces of cake that you can imagine.
Unsurprisingly, he's an accountant.
And, yeah, exactly. And a very good one, I might add. But that deadlock over who gets the cake is resolved. Okay. Well, how in the world does that play out in a corporation or in an LLC? Well, Caleb and I are deadlocked, and so now our resolution is we have to go our separate ways. One is buying out the other. That's what the cut and choose or shotgun method does. And so once one of us, and again, this has to be in your agreement. There's no default for any of this. But if it's in your agreement, what it's going to happen is one of us is going to, either Caleb or I, are going to declare a deadlock. And while we declare that deadlock, we're going to write down a number on a piece of paper. Okay. And we're going to throw that number figuratively onto the table. And when we do that, we don't know if we're buying or selling. Okay. So Caleb and I aren't speaking. We can't decide, we can't agree if it's day or night or what color the carpet wants to be. So I've decided, I've thrown up my hands, enough, deadlock, and I throw $5. I write $5 on the piece of paper. Caleb now gets to decide if he wants to buy me for $5 or I'm going to buy him for $5. And the idea here is that from an economic perspective, whoever values the entity the most is going to buy it. And that's an efficient result that an economist would say. Now, this solution actually, it works very well most of the time because it's never implemented. People don't want to take that risk. I don't know how much. So it forces Caleb and I to act like adults and lock ourselves in a room and have a conversation. But if not, and this is what I wrote about yesterday, a case out in New York, where again it was a family and they couldn't figure it out, and a lot more dollars than 5 were involved in that case. And so how you go about, we have to go our separate ways. The business needs to continue, has to happen quickly. That's a real benefit of cut and choose. And as long as you have parties who have the same amount of information and who are relatively equal economically, this is a real efficient way to resolve a deadlock. But when you have unequal bargaining power, so if Caleb has all the money, and I mean, what is it really? He's gonna cut me off at the knees, and that's not gonna work. So you got to be careful as you implement that, and be thoughtful about, hey, is this proper for us to have this shotgun or cut and choose method? So then the last one here on the slide is what I just call full sale or dissolution, without having to have judicial dissolution again for a judge to decide all that. You just say, all right, we're deadlocked. Now all the assets need to be sold. And so now you're just going to divide up money. Money is easy to divide up, not the assets. And it's easy to say, oh, we're just going to sell all the assets. There's still some more questions there, right, Caleb? Like, how are we going to sell the assets? Who is going to sell the assets? Who between you and I has the authority to deal with all of this stuff? So, lots of different techniques and lots of different layers to all of these things, but it's really simple in terms of the concept. There is going to be a deadlock, could be because in just about any business, whether you have equal members or odd members, I mean, things change over time. So even in businesses that have an odd number of humans involved or different percentages, we regularly build in a deadlock resolution provision because you never know when they're going to arrive. And so I would just reiterate that idea that if you can foresee it, you have a duty to plan for it. And we do a ton of this sort of stuff. And it's way better to do it at the outset. And when everyone is still talking and you can work through it like adults. But hopefully these are some proposed solutions that will at least get you thinking about your situation. And so again, whether you're a corporation or whether you're an LLC, there are different things that should be used. If you're a corporation, you got to have a shareholder agreement. If you're an LLC, you got to have an LLC agreement, and get it in writing. And please don't get it off of Google. These documents, we see just terrible documents, and it costs you so much money in the long run. So we're here to help. Call Caleb, call me. We've got a lot of other business lawyers here at Beresford Booth. We'd be delighted to help you solve these so that we hopefully can keep your family together, keep father and son still talking with one another. Caleb, what did I forget here, Caleb, as I've been chiming on here endlessly?
One thing I think would be important to talk about is sort of what you generally see in terms of whether the relationship between the parties that are forming the entity, how that sort of affects what you generally recommend in terms of these deadlock resolutions, and whether is there such thing as a one size fits all, or is this really, or do you have to think about everything that the parties are doing and what they're involved in before you pick a method for resolving deadlock?
Yeah, no, it's a great question, and there definitely is not a one size fits all. Every family is different. Every business is different. I mean, and it really is true. I mean, every law firm is different. Every accounting firm is different. Every real estate venture is different. And so you do have to start with, what is the pre-existing relationship? If it's a family relationship, well, you want to make sure that you pick a deadlock resolution technique that you may get separated in terms of the business relationship, but you don't want to kill the family relationship. So a resolver methodology may be better in that situation than, for example, a cut and choose or arbitration. All right, because the cut and choose is great. You're going to have this nice clean break. Well, you and I are still going to see one another at Christmas, Caleb. So let's figure out a way that, I still get a good gift every year, right? And by the same token, if I'm just a capital guy, if I'm a venture capital fund and I'm just writing checks, I don't really care much about preserving relationship. I'm going to come in. I've got an obligation to my shareholders and so or to my members, partners. And so I'm not so concerned about my relationship with you. So I just want to get away from you and preserve the business and preserve my, my personal guarantee that hopefully doesn't get implicated. So cut and choose or some kind of offshoot of that would be much more advisable in that kind of situation. But every situation and every relationship is different, and it really is important. And LLC agreements, shareholder agreements, they take time to draft. And it's why I say, don't just grab it off the internet, because it's your business is more special than Google. It's more special than whatever Zoom legal is selling you. And we've been doing this a long time, and you do need to be thoughtful about that stuff.
And we know when people pull it off the internet.
Oh boy, that's right. Caleb, you're too young to remember the Fram oil filter commercial, so I will say it. The Fram oil commercial said, "You can pay me now," meaning buy an oil filter and change your oil regularly, and you pay a little bit, or you'll pay me later, which is a whole lot of money when your engine collapses. Your business is your engine. We don't want that to happen. We want your business to continue. We want you to thrive. We want your family to thrive, and all of your relationships to continue in a positive manner, because business litigation is really quite an expensive proposition. So looks like our time is up. Caleb, thanks for hopping on and participating. Again, we'd love to help you. Give us a call, shoot us an email, and our contact information is right here. Call either Caleb or me, or again, we have lots of other business lawyers here. Check us out on our website, beresfordlaw.com. Love to work with you. Caleb, you get the last word.
It was a lot of fun. Please do not be the person that pulls something off the internet.
Well said. All right. Thanks, everybody. Appreciate it.
Thank you.